We are watching the Second Amendment landscape transform right before our eyes, and what's happening right now is something that a lot of people are missing. The legal framework has fundamentally shifted, and the implications are massive. We're not talking about some distant future possibility. We're talking about active litigation happening in courtrooms across this country that could reshape gun laws as we know them. So let's break down exactly what's going on, why it matters, and what comes next. Before we jump in, if you want to support the channel, one of the best ways to do that is simply to subscribe and turn on notifications. That helps ensure you don't miss these updates as this situation continues to develop. I also want to thank the sponsor of this video, Attorneys on Retainer. When it comes to self-defense protection, in my opinion, they're in a league of their own. They're backed by an actual law firm, Attorneys for Freedom, and they provide real legal coverage with real attorneys when you need them most. If you own firearms for self-defense, you need legal protection. That's the reality we live in. Check them out. I'll link them below. So here's what's actually happening. The Department of Justice under Attorney General Pamela Bondi has undergone what can only be described as a complete transformation in how it approaches Second Amendment issues. And I'm not exaggerating when I say this is unprecedented. For decades, the DOJ has been on the opposite side of gun rights cases. They've defended federal restrictions, they've supported state bans, they've been the enemy of the Second Amendment at almost every turn. But that has changed dramatically. In late 2025, the DOJ did something that shocked everyone who's been following this issue. They created a dedicated Second Amendment rights section within the Civil Rights Division. Think about what that means for a second. The federal government now has lawyers whose entire job is to treat the right to bear arms as a core civil right, not as something to be regulated into oblivion. This isn't just symbolic. This is a fundamental shift in how the executive branch approaches gun rights. And they're not just creating offices and writing mission statements, they're taking action. In December 2025, the DOJ took the unprecedented step of suing the District of Columbia. This is the federal government suing a jurisdiction within its own borders over gun rights. The lawsuit alleges that Washington, D.C.'s ban on semi-automatic firearms, including AR-15 style rifles, and its restrictive registration system are unconstitutional. The DOJ is arguing that D.C. has created a pattern and practice of constitutional violations specifically designed to discourage legal gun ownership. But it doesn't stop there. The DOJ is also suing the United States Virgin Islands, claiming the territory is systematically denying residents the right to carry firearms. This marks the first time the federal government has sued a U.S. territory to enforce the Supreme Court's Bruen decision. And in January 2026, the DOJ joined 25 states in filing an amicus brief in a case challenging California's ammunition background check laws, calling the system a convoluted board game that fails basic constitutional scrutiny. What we're seeing is the DOJ going on offense. They're not waiting for cases to come to them. They're actively seeking out jurisdictions that have restrictive gun laws and challenging those laws in court. And when they file these lawsuits and these briefs, they're using the framework that the Supreme Court established in the Bruen decision. That framework is text, history, and tradition, and it's absolutely devastating to gun control laws that can't meet that standard. Now let's talk about what Bruen actually did, because this is the foundation for everything that's happening right now. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen, and in that decision, the court did something that Second Amendment advocates had been begging for. They ended interest balancing. For years, lower courts used a trick where they would say, sure, you have a Second Amendment right, but the government has a compelling interest in public safety, so we're going to let them restrict that right anyway. That was the framework, and it allowed almost any gun control law to survive constitutional scrutiny as long as a judge thought it sounded reasonable. Bruen ended that. The Supreme Court said no more interest balancing. The test is now whether a restriction is consistent with the nation's historical tradition of firearm regulation. If the government wants to restrict your Second Amendment rights, they have to point to a historical analog. They have to show that this type of restriction existed and was accepted during the Founding Era or during the Reconstruction Era when the 14th Amendment was ratified, and if they can't do that, the restriction is unconstitutional. Period. This was a massive shift. And what it did was put every gun control law in this country under a microscope. Suddenly, laws that had been on the books for decades were vulnerable. Assault weapon bans, magazine capacity limits, licensing schemes, carry restrictions, all of it had to be justified under this new historical test. And a lot of these laws can't meet that test. So what happened after Bruen? Well, the Supreme Court sent a bunch of cases back down to the lower courts and told them to reconsider those cases using the new framework. And that's where things got interesting because some lower courts complied, and some lower courts basically said, we're going to ignore you. Courts in the Fourth Circuit, the Seventh Circuit, the Ninth Circuit, They found creative ways to uphold gun control laws even after Bruen. They invented new definitions. They cherry-picked historical examples. They essentially told the Supreme Court, we heard you, but we're going to do what we want anyway. And that brings us to where we are now. The Supreme Court is watching. They're seeing how lower courts are handling these cases. And they're deciding which cases to take up next to clarify exactly what Bruen means and how it should be applied. Right now, there are several cases on the Supreme Court's docket, or potentially heading there, that could have enormous implications. One of the biggest is United States versus Himani. This case deals with whether the federal government can permanently disarm someone for using marijuana. Now, marijuana is legal in a lot of states, but it's still illegal under federal law. And federal law says that if you're an unlawful user of a controlled substance, you can't possess a firearm. So this case is going to determine whether that prohibition survives under Bruen's historical test. And the implications are huge because millions of Americans use marijuana in states where it's legal. Are all of those people prohibited from owning guns? That's the question the Supreme Court is going to have to answer. Another major case is Woolford versus Lopez out of Hawaii. This case challenges Hawaii's law that bans carrying firearms on any private property that's open to the public unless the property owner posts a sign specifically allowing it. So in Hawaii, you can't carry in a restaurant, you can't carry in a store, you can't carry anywhere unless there's a sign that says you can. This is obviously a massive restriction on the right to carry, and it's being challenged under Bruen. If the Supreme Court takes this case and rules in favor of gun rights, it's going to invalidate carry restrictions in jurisdictions all across the country. There's also Range versus Attorney General, which deals with whether non-violent felons can be permanently disarmed. The circuits are split on this. Some say that any felony conviction, even a non-violent one, is enough to strip someone of their gun rights forever. Others say that only violent felonies should result in permanent disarmament. The Supreme Court is going to have to resolve that split. And there's a related case involving a woman named Melinda Vincent, who was convicted of check fraud 17 years ago and is still prohibited from owning a firearm. Her case has been relisted by the Supreme Court 5 times, which suggests the justices are seriously considering taking it up. And then there's the big one, the one that everyone is watching, the question of assault weapon bans. Several states have laws that ban AR-15 style rifles and other semi-automatic firearms. Maryland, California, New York, New Jersey, Connecticut, Massachusetts, Illinois, Hawaii, and the District of Columbia all have some version of an assault weapon ban. And all of those bans are now being challenged under Bruen. The Fourth Circuit recently upheld Maryland's assault weapon ban in a case called Bianchi versus Brown. The court said that AR-15s are like Bowie knives and sawed-off shotguns, dangerous and unusual weapons that can be banned. Gun rights groups immediately appealed to the Supreme Court, but in June 2025, the Supreme Court declined to hear the case. And that frustrated a lot of people because it meant the court was leaving the question unresolved. But here's the thing, just because the court didn't take that case doesn't mean they're never going to address the issue. The court is strategic about which cases it takes. They want a clean case with a good record and clear legal questions. And there are other assault weapon ban cases working their way through the system right now that might be better vehicles for the Supreme Court to address this issue. In fact, a federal judge in New Jersey recently declared New Jersey's AR-15 ban unconstitutional. The judge said that as a lower court, he was bound to follow the Supreme Court's direction in Bruen, even if he personally disagreed with the policy outcome. That case is now being heard by the full Third Circuit, and depending on how that goes, it could end up at the Supreme Court. And if it does, the court is going to have to finally answer the question, can states ban AR-15s? Now, here's where the DOJ's involvement becomes absolutely critical. Remember, the DOJ is now actively challenging gun control laws, they're filing lawsuits, they're filing amicus briefs, and when the federal government takes a position on a constitutional question, courts pay attention. So when these assault weapon ban cases get to the Supreme Court, the DOJ is going to be there arguing that these bans are unconstitutional, and that's going to carry enormous weight. The DOJ's argument is going to be based on what's called the common use test. This comes from the Supreme Court's decision in District of Columbia versus Heller back in 2008. In Heller, Justice Scalia wrote that the Second Amendment protects arms in common use for lawful purposes, and the court said that weapons that are commonly owned by law-abiding citizens for self-defense cannot be banned. So the question becomes, are AR-15 style rifles in common use? And the answer is undeniably yes. Current estimates put the number of AR-15 style rifles in civilian hands at somewhere between 20 and 25 million. These are the most popular rifles in America. They're used for self-defense, For sport shooting, for hunting, for all lawful purposes. By any reasonable measure, they are in common use. And that's exactly what the DOJ is going to argue. They're going to say that with 20+ million of these rifles in circulation, owned by millions of law-abiding Americans, these are textbook examples of arms in common use. And under Heller and Bruen, arms in common use are protected by the Second Amendment. States can't ban them just because they think they're scary or dangerous or military style. The test is common use, and AR-15s meet that test. Now, states are going to argue back. They're going to say that even if AR-15s are common, they're also particularly dangerous, and that danger justifies a ban. But the Supreme Court has already addressed this argument. In Heller, Justice Scalia wrote that the Second Amendment does not protect only those arms that are suitable for sport or hunting. The Second Amendment protects arms that Americans choose for self-defense, including arms that might be useful for military service. The fact that a weapon is effective or powerful does not disqualify it from Second Amendment protection. If anything, it reinforces that protection. The Supreme Court has also said that the Second Amendment historically protected exactly the kinds of arms that would be useful for militia service. The founding generation understood that an armed citizenry needed access to effective weapons. They didn't limit the Second Amendment to muskets or to arms that weren't dangerous. They protected the arms that citizens would actually use to defend themselves and to defend the state. So when you put all of this together, the legal argument against assault weapon bans is extremely strong. You have the common use test from Heller. You have the historical tradition test from Bruen. You have the DOJ now actively arguing that these bans are unconstitutional. And you have a Supreme Court with a 6-3 conservative majority that has shown a willingness to enforce the Second Amendment as written. Does that mean assault weapon bans are definitely going away? Not necessarily. The Supreme Court could still decline to take these cases. They could issue narrow rulings that don't resolve the broader question. Lower courts could continue to resist and find ways to uphold bans despite Bruen. This is going to be a fight, and it's going to take time. But the trajectory is clear. The legal foundation for assault weapon bans is crumbling. The arguments that states used to rely on, arguments about public safety and dangerous weapons and military-style features, those arguments don't work anymore under the Bruen framework. States have to show a historical tradition of banning commonly owned firearms, and they can't do that because that tradition doesn't exist. You know, for the longest time, the debate over assault weapon bans was purely political. It was about which party controlled the legislature, which governor was in office, which activists had more influence. But Bruen changed that. Bruen made this a legal question with a clear legal test. And when you apply that test honestly, assault weapon bans fail. So what happens next? Over the next year, we're going to see a flood of litigation. Gun rights organizations like the Firearms Policy Coalition, the Second Amendment Foundation, and others are going to be filing challenges to every assault weapon ban in the country. The DOJ is going to be filing briefs supporting those challenges, and courts are going to have to rule on whether these bans can survive under Bruen. Some courts are going to uphold the bans, some are going to strike them down, and eventually, the Supreme Court is going to have to step in and resolve the conflict. When that happens, when the court finally takes up an assault weapon ban case and issues a definitive ruling, that ruling is going to reshape gun laws across the entire country. If the court says that AR-15s are protected arms and that states cannot ban them, every assault weapon ban in America falls. California, New York, New Jersey, all of them. Gun owners in those states will finally be able to purchase and own the firearms they want for self-defense. And states won't be able to pass new bans because the Supreme Court will have settled the question. Now let's also talk about what this means for other types of gun control. Because if the common use test applies to rifles, it also applies to magazines. Standard capacity magazines, the ones that hold 30 rounds, are in common use. There are hundreds of millions of them in circulation. If AR-15s can't be banned because they're in common use, then magazines can't be banned either for the same reason. And this logic extends to other restrictions as well. If a particular accessory or component is commonly owned and commonly used for lawful purposes, then bans on that item are going to be unconstitutional. The Bruen framework doesn't just apply to complete firearms. It applies to anything that's protected by the Second Amendment, and the Supreme Court has said that you can't separate a firearm from its necessary components and claim that banning the components doesn't infringe on Second Amendment rights. We're also seeing challenges to licensing schemes that make it effectively impossible to own or carry firearms. Some states have laws that require extensive training, multiple fees, long waiting periods, and subjective approval by law enforcement. And all of those requirements are now being challenged under Bruen. Because if there's no historical tradition of requiring a license to exercise a constitutional right, then those licensing schemes are unconstitutional. The same goes for carry restrictions. After Bruen, states can't require you to show a special need or good cause to carry a firearm. That was the whole point of Bruen. The court said that the right to carry is a fundamental right, and states can't turn it into a privilege that's only available to people who can convince a bureaucrat that they deserve it. So we're looking at a comprehensive transformation of gun laws in this country, and it's all happening because of the framework that the Supreme Court established in Bruen and the willingness of the DOJ to enforce that framework. Now, I want to be realistic about the timeline here. This is not going to happen overnight. These cases take time. Appeals take time. Even when a ban is struck down, states often try to rewrite their laws to make them narrower or to make them more defensible. And then those new laws get challenged, and the whole process starts over again. But the momentum is on the side of gun rights. The legal arguments are strong. The Supreme Court has laid out the framework. The DOJ is backing it up. And gun rights organizations have the resources and the determination to fight these battles in every jurisdiction where gun control laws exist. For gun owners, this is an incredibly important time to stay informed. If you live in a state with restrictive gun laws, you need to be following the litigation in your state. You need to know which cases are pending, which laws are being challenged, and what the outcomes are, because these cases are going to directly affect your rights. And if you're someone who cares about the Second Amendment, you should be supporting the organizations that are doing this work. The Firearms Policy Coalition, the Second Amendment Foundation, Gun Owners of America, these groups are on the front lines of this fight. They're the ones filing the lawsuits, hiring the lawyers, and pushing these cases all the way to the Supreme Court. Without them, none of this would be possible. We're also going to see how states respond to adverse rulings. Some states are going to comply, they're going to repeal their unconstitutional laws and move on, but other states are going to fight. They're going to try to rewrite their laws, they're going to try to find loopholes, they're going to try to delay implementation, and that's going to create more litigation and more opportunities for the courts to clarify exactly what the Second Amendment protects. This is a long-term process, but it's a process that's moving in the right direction. For decades, gun rights advocates have been on defense. They've been fighting to stop new gun control laws from passing, but now they're on offense. They're going after existing laws, they're pushing to expand gun rights, not just to preserve them. And that shift is incredibly significant. The ultimate goal is a legal landscape where the Second Amendment is respected the same way we respect the First Amendment or the Fourth Amendment, where courts don't treat gun rights as second-class rights that can be regulated into oblivion, where the right to keep and bear arms is understood as a fundamental constitutional right that belongs to all law-abiding Americans. We're not there yet, but we're closer than we've ever been. And with the Supreme Court, the DOJ, and gun rights organizations all pushing in the same direction, we're going to continue making progress. So as this situation develops, I'm going to keep you updated. Every major ruling, every significant case, every move by the DOJ, I'll break it down and explain what it means for gun owners. This is an ongoing story with multiple chapters, and we're right in the middle of it. Make sure you're subscribed and have notifications turned on so you don't miss these updates. Hit that like button if you found this breakdown helpful, and drop a comment below and let me know what you think. Do you think assault weapon bans are going to fall? How long do you think it's going to take? I want to hear your thoughts. As always, thank you for your support. Stay informed, stay engaged, and remember that this fight for our constitutional rights is far from over, but we're winning.